Welcome back to This Week in Immigration. I'm Rachel Iacono. On this week's episode, we are joined by special guest and BPC Fellow Ruth Wasem to discuss the recent Supreme Court ruling on temporary protected status and its ramifications for TPS holders across the United States. We'll then turn to This Week regular Theresa Cardinal Brown for the latest updates on Vice President Kamala Harris's trip to the southwest border. More of that to come, so stick around. Earlier this June, the Supreme Court unanimously ruled that non-citizens who have been granted temporary protected status cannot use the process known as adjustment of status to obtain lawful permanent residency in the United States without first leaving the country if they originally entered illegally. The court ruled that adjustment of status is reserved for those who were inspected at the border and admitted to the United States by an immigration officer, thus disqualifying the majority of those granted TPS from the in-country process for obtaining green cards. As many as 400,000 immigrants have been granted TPS in the United States, which means that they are allowed to stay because of unsafe conditions or crises in their native countries. With us today to talk about TPS and the ramification of this ruling is BPC Fellow Ruth Wasem. Ruth, welcome back to the show. I'll pass things over to Theresa to kick off your conversation.
Hi, Ruth. Welcome back.
It's always a pleasure to be with you on this show.
So, Ruth, first, why don't you give us some background on the TPS program? When was it created? What countries have been granted TPS, and how has it been used?
Well, TPS dates back to the 1990 Immigration Act, which was a series of amendments and was one of the last significant revisions to U.S. immigration law. It grew out of a concept known as temporary safe haven that had been kicking around for many years in the international migration movement as something to deal with individuals who are fleeing humanitarian crises, but they don't necessarily meet the definition of a refugee, that is, having a well-founded fear of persecution on one of the 5 characteristics. It also generally, when you think of the concept of safe haven, it assumes that the host country is a country of first asylum. So it's individuals who are fleeing to a neighboring country to seek refuge, but they may not meet the definition of a refugee. So it was out of this thinking, and this is going to be, as Yogi Berra would say, deja vu all over again. In the context of the United States, it was during the civil wars in Central America when there were large numbers of Salvadorans, Guatemalans, Nicaraguans fleeing to the United States, many of them civilian non-combatants who didn't meet the definition of a refugee because they had difficulties proving individual persecution, but they were clearly fleeing dangerous situations. Now, the executive branch, as you know, Theresa, does have some discretionary authorities to give blanket relief from removal. But it got very political at that time then, and administrations would do it kind of when it suited them. Congress decided to assert itself by creating a section in the law that is now known as temporary protected status, that embodied temporary safe haven and specified these are the conditions when the executive branch should grant blanket relief to these individuals. So it's generally when there's civil war or natural disaster or other things that are of special humanitarian concern to the United States. So it was trying to delineate and define when the executive branch should grant blanket relief. Not based, and so one of the key concepts here from the beginning is that the individual doesn't have to prove that they are particularly at risk. They just prove they're from this location in this country where something dangerous is going on.
As we mentioned, a lot of different countries have had TPS. Just this last week, the Biden administration redesignated Yemen for temporary protected status. You mentioned the Central American countries who have had temporary protected status. There have been countries in Africa that during Ebola had temporary protected status. Some have come and gone, some have been temporary. Others have remained and had temporary status reissued or redesignated for many, many years. Why has the temporary status not necessarily been temporary?
We'd all like to think peace would break out in these war-torn situations, and it frequently doesn't happen. So when we look at countries, the kind of classic examples of short-term temporary protected status in the past was Montserrat, where there had been an earthquake, Kuwait, after Saddam Hussein had invaded and the United States went in Desert Storm, Bosnia-Herzegovina, when Yugoslavia was breaking up and the violence there. These were cases when it was really for a rather short period of time. Then we have other parts, like El Salvador was actually the first country to have temporary protected status because that was part of the original legislation. Congress said that El Salvador would have temporary protected status for 18 months. And they've essentially had TPS or some form of that ever since. And other countries like Haiti, and this is something I hope we talk a little bit about today, because some countries go back and forth between TPS and then deferred enforced departure, where they're and these other forms of blanket relief from removal that the executive branch uses. The other thing that happens with the temporary is, and this is an important concept our listeners need to appreciate, temporary protected status is not prospective, it's retrospective. So you have to already be in the United States when it's issued. And it was originally envisioned as someone, you could be a foreign student studying in the United States, and there's a hurricane that hits your country, and where your family lives is devastated, and you can't go home, even though you're graduated and your visa's expired. That's one of the things that was envisioned. But when these things continue, the TPS, it's not for someone from that same country, for like your family to say, well, we're going to join our student in the United States and get on the next flight. You don't arrive and apply for TPS. You have to have already been here. So what happens on these ongoing redesignations? And that's when we move the date up. So recently, the declaration for Yemen didn't just renew it for the people who already had TPS, they moved the date up. So that's up to July 5th now of this week. The Haitians who got temporary protected status in May, that was issued on May 22nd, added another a sizable portion of Haitians who had arrived between the last designation and May 21st of 2021.
As you said, some of these designations, like El Salvador, have been in place for over 30 years. And if you're here 30 years, you're not temporary. But let's go back to the Supreme Court ruling that Rachel talked about, right? So temporary protected status doesn't necessarily grant you a status from which you could get a green card. It's supposed to be temporary. It allows you to work. You can't be deported, but you can't get a green card necessarily. There was a narrow provision that some courts had allowed that said, well, temporary protected status could be considered an admission, so that if you had an ability to get a green card, so you had a U.S. citizen, family member who could sponsor you, or an employer who sponsored you, you might be able to get a green card. And the Supreme Court said, no, that's not enough. And so now what does that leave? Does that mean that means that most people who came on TPS who maybe entered illegally don't have a way to get a green card, but they've been here 30 years?
And it essentially, and this sounds like we're splitting hairs, but there has always been an immigration law and policy a distinction made between people who lawfully arrived and people who entered without inspection or came in, surreptitiously. And if you lawfully arrived, and then, like I said, you're an international student and something happens in your home country, and an employer wants to hire you, you're seen as being having been admitted to the United States, so you can adjust status. But for people who have not, and I looked at the data in preparation for our conversation, and most people now with TPS are people that entered without inspection. Overwhelmingly. That means they are not considered to have lawfully entered for the purposes of adjustment of status. So the executive branch, even if they qualify for a visa, they're held to the bars that were put in the law in 1996. So a lot of these bars were added after TPS was created, 6 years later, that restrict the ability of people to adjust status. And as a result, most people with TPS will not be able to become a lawful permanent resident unless Congress passes legislation.
So just to clarify for our audience, these bars, what it means is that if you can't adjust status, even if you are in line for a legal green card and one is available, you qualify in every other way, you would have to leave the country and try to apply for a visa outside the United States, except the fact that you've been in an undocumented status in the United States can prevent you from being eligible for some period of time. Or, for example, if you were previously deported and came back, you may be ineligible at all, period. So that's why, as you said, they can't adjust. They can renew TPS as long as it exists, but they can't adjust. They can't sponsor family members or any of the other things that green card holders could do. Correct?
Correct. It's like immigration purgatory, really. I mean, you're not, you're not sent back, but you're not here in any legal sense. You can work. There are basic things you can do. You run risks if you leave the country. Because then you don't have a way to get, it gets incredibly complicated.
I'm thinking very clearly that this seems very similar to the situation of the Dreamers that we've talked about, right? These are people who came illegally as children, when they were young. They have lived here their entire lives. Even, they now maybe have DACA status, and DACA is similar to TPS in that it provides this protection from removal and work authorization, but not necessarily the ability to get a green card. So we've seen, for example, Congress has introduced legislation that would legalize both Dreamers and TPS holders. And I think there's been an increased movement to look for legalization for the TPS holders. Like bills such as the Dream and Promise Act that passed the House earlier this year. Do you think that's why they're linking these groups together, that their situations are similar? The government has said you can stay, but that's it?
Well, I think that the similarity is, and particularly with people with TPS, is they've built up equities in the community. They've lived, they've worked here, they've contributed to communities.
A lot of them have U.S. citizen kids born here, right?
Citizen kids. They have not been a drain on society. They're not eligible for any federal benefits or assistance.
They're legally working and paying taxes too. Let's be clear. They're working above board.
We're profiting from them being here. And if they were to do, if a random person with TPS did commit a crime or do something untoward, then they would be removable. They would no longer have TPS. So it's
right. You have to pass a background check to get TPS in the first place, or renew it every 18 months, right?
Yeah. So these are people that are vested in the community and are people we've invested in the sense of they're part of us when they've been here this long. And it raises the issues of where they would go back. My favorite example, of course, are the Liberians. They had it for the longest continuous period of time. There had various times been legislation introduced to adjust the Liberians, and it wasn't until 2 years ago that a provision was included in an appropriations bill. Now, they had TPS, then they had deferred enforced departure. They had various different statuses. There would be a civil war in Liberia, then things would get better, and then it would get bad again. And it was just one of those situations where we were talking about a small number of people. So sometimes with most of the adjustments of status, it really is done on a country-specific basis, which raises the question of cherry picking. And this is where a lot of this stuff gets, let's say, delicate. Do you do everybody with TPS, or are some people from countries that have been, or individuals who've been here a longer period of time, are they more meritorious? Do they have a more compelling case? Are they more rooted in the community? Should they get to adjust, but not necessarily someone who recently got TPS? Is there a sell-by date for TPS? These are things that, some people may want to differentiate, but temporary protected status is, individuals with that are generally seen as more attractive among the people in the United States without status.
Well, at least rhetorically, you can argue that the government has permitted legally, like literally issued them a permit to stay. It's other undocumented people who are literally undocumented. I would think TPS holders are not accurately described as undocumented. They are documented and they are authorized. They just don't have a status from which to apply for any other immigration benefits. But, Congress is looking at this. I think there have been some discussions, but one of the things that keeps coming up, and you kind of touched on this a little bit earlier when you were talking about the differences between TPS and asylum, right? We have this issue now with a lot of people, some from the countries that have TPS, coming to our border right now and seeking asylum, and lots of questions about whether the generalized crime in Honduras is enough to qualify somebody for asylum, right? Asylum, as you mentioned, is an individualized determination, but we're seeing, thousands of people come from those countries. Is it time to revisit what temporary protected status is meant to do? Or is it time to revisit asylum? Or do we need to think again about a different kind of protection altogether?
And that's where the whole issue of when you adjust the status to lawful permanent residents of people who had TPS, it makes it more difficult, arguably, to keep it as an available policy tool for temporary crises, or for that category of individual who doesn't quite meet the threshold of a refugee or an asylee, but has a compelling situation. One of the concerns when the provision was put into statute was that, as Senator Alan Simpson said, there's no such thing as a temporary. Nothing is more permanent than a temporary immigrant kind of thing, and that's why in the law you can't grant. Congress cannot give temporary protected status individuals lawful permanent status without a supermajority vote. You can't have a simple majority. It's a higher threshold. They made it very difficult. And arguably, when you see an executive branch shift a population from TPS to deferred enforced action, it's often done so that it's easier to let them become lawful permanent residents.
So we're finding ways to work around the statute that hasn't been updated in 30 odd years again. Yeah. That's a refrain that's common on this podcast.
It is an attractive concept to have this middling category of individuals that you want to protect, that you feel it's morally important, that it's within the customs and values of the United States to give protection to, but not necessarily put them on a pathway to permanent residence. So the temporary side of it, if you think it can work temporarily, then the concept of safe haven is still a very good one. But if it's perceived of as a pathway to permanence, it loses its broad-based appeal to handle temporary situations.
Well, Ruth, as always, you have enlightened us on the history, on the technicalities. Thank you very much, Professor Wasem, for joining us again today on This Week in Immigration.
Always a pleasure, Theresa.
For our final segment, we turn to immigration news with This Week regular Theresa Cardinal Brown to discuss Kamala Harris's recent trip to the U.S.-Mexico border. 2 weeks ago, Vice President Kamala Harris visited El Paso, Texas, in her first trip to the border in office. Her trip came after relentless criticism from Republicans, who accused her of avoiding the border and ignoring what they say is a crisis of illegal immigration and drug trafficking. So, Theresa, we've touched on the vice president's role in addressing the root causes of migration to the southern border before. And on the surface, the visit seemed pretty tit for tat to appease Republican criticism. So can you talk about what the exact purpose of the trip was and what was actually achieved?
Well, the purpose of the trip probably was twofold. I'm sure that there was a intention to respond to Republican critics that she hadn't been to the border since she'd been vice president and been charged with dealing with the root causes of the migration to the border. On a more mundane side, she went to the border and toured facilities and talked to migrants. She toured Border Patrol facilities where migrants are taken after they are apprehended. She toured a port of entry in El Paso, the Paso del Norte port of entry, where she watched operations there. She met with local aid groups that assist immigrants who have arrived. She was there with DHS Secretary Mayorkas, Senator Dick Durbin, and Representative Veronica Escobar, who are both Democrats. And this all took place in El Paso, which is on the west end of Texas. So she did get some operational briefings. She had a chance to talk to some young immigrant girls about, unaccompanied girls about their migrant journey. I'm sure it was educational. Did it have a substantive policy outcome? No, not really. She didn't visit Fort Bliss, the HHS facility for unaccompanied migrant children that was reported to have terrible conditions and has since been slated to be closed. She didn't visit the Rio Grande Valley, which is where the majority of migration is happening right now of families and unaccompanied children. She was in the other end of the state, and that was a criticism that some Republicans gave to her. But I think, as I've said before, it's not as if Senator Harris, when she was senator, didn't visit the border. She had been to the border before. She had dealt with some of these places. I think this was as much a political tour as anything else. And again, her role is not to necessarily address what is happening at the border, but to address the root causes. So probably the most important thing she heard was from the immigrants themselves about the conditions in their home country and what would have made them stay. And that's something that maybe she'll be able to take back with her when she continues her conversations with the governments in Central America. There definitely is still a lot to be done to address migration at the border and in the region, but we didn't see any major announcements come out of it.
So jumping off of that, with the White House so focused on infrastructure lately, do you think this visit will, potentially spark the White House's attention and they'll maybe turn towards more concrete reform in this area?
Well, I'm not sure that the White House is going to invest a lot of political capital on immigration on Capitol Hill right now. They are really vested in getting the infrastructure package done, although it's worth repeating that the reconciliation package for the fiscal 2022 budget that Congress is considering may be a vehicle that many advocates are hoping will contain legalization provisions. What we have seen, however, is an uptick in what we think is a lot of administrative, operational, and policymaking action that might have more impacts. There are increasing reports in the press that the administration is considering taking down Title 42, which we've talked about, is the CDC order that allows DHS to expel migrants without any immigration processing that's been applied to most single adults arriving at the border and many families. There's been just yesterday a notice that the Department of Homeland Security has sent a new rule to the Office of Management and Budget for review and posting in the Federal Register that would allow asylum officers to conduct initial asylum decision-making for people who arrive at the border so that these cases didn't necessarily have to go to immigration court. So it does appear that the administration is trying to make policy and operational changes, but it's unclear what that's going to mean on the ground and how quickly those kinds of things will happen.
So you mentioned this a little bit, and I want to turn back to your mention of the rumors about Title 42 potentially ending. A lot of people are saying that if the administration chooses to do that, it'll lead to a new rush at the border. So what do you think the challenges are for the administration of ending this order if they choose to move forward?
Well, it's important to note that there have been challenges to the existence of this order since President Trump put it in place in March of 2020. There are at least 2 federal court cases that argue that it's illegal to deny immigrants a chance at asylum in the name of public health orders. So I think Title 42 was already kind of under a lot of pressure. The Biden administration had been negotiating with the ACLU on one of those court cases to kind of figure a way out of the conundrum. Operationally, Title 42 has meant that the majority of migrants encountered are sent back to Mexico, and that has allowed the administration to manage a lot of migration. Should that order come down without any other changes in policy or regulation, every migrant encountered, Mexican and non-Mexican, would have to be taken in by the Border Patrol, have to be processed under immigration law, allowed a chance, if they ask for it, to make an appeal for asylum, incredible fear. Many of them will probably be put into proceedings in immigration courts. Some may be returned to their home countries under expedited removal, but that would still require the United States government to house them and probably keep them in detention until they can remove them. We might see an uptick in migrants put into ICE detention facilities. Families may be released into the country. I do think that it is likely to encourage more migration because, at least as the process exists now, migrants that would come to the border subject to that would most likely be released and allowed to stay in the country pending the outcome of their proceedings, which could be 2 to 5 years. That's long enough to make probably it worth their while to try to come to the United States. So absent other changes in policy or process, or other factors such as Mexico increasing its enforcement of its border with Guatemala to limit the number of people coming north, I do think it could result in more migration that the Biden administration is going to have to manage in some way. So a lot of this is going to depend on timing. If this new asylum rule that might allow asylum adjudications to happen faster, including approvals and denials, but if that takes several months to put in place and Title 42 comes down sooner, you have a problem of what to do in the meantime. So I think this is the conundrum that the Biden administration is in, trying to manage the expectations and hopes of immigrant advocates and asylum rights advocates who say that the Title 42 order is illegal and should be taken down immediately, with the operational imperative to manage in a thoughtful way migration that's happening at the border and be able to do so in a humanitarian way, but that doesn't necessarily encourage a lot more migration. So this is the conundrum that they're in, and I think we just have to see how it all plays out.
Thanks, Theresa. I think that's the perfect way to end the segment. A lot more things to track and discuss as we monitor Title 42 in future episodes. And speaking of the next episode of This Week in Immigration, it is bittersweet that I have to announce to all of our listeners that this is my last episode as your host of This Week in Immigration. I will be leaving the lovely BPC at the end of July for graduate school at Georgetown, and consequently my time on this podcast has to end. So stay tuned for another episode in 2 weeks where we introduce our new host. So keep your eyes out for that one. And, thank you to Theresa and the incredible team and all of the editors and producers and Ethan in the background for giving me the opportunity to host all of these episodes.
Well, Rachel, I just want to say a personal thank you to you. In addition to being host of This Week, you have been the rock and steady hand on our immigration policy project, the Bipartisan Policy Center. You will be missed both here and in the work that we do every day, but we wish you great success at Georgetown. And I am sure that we will hear you on another podcast somewhere in the future.
You definitely will be. This has become a true pandemic addiction, so to speak. I didn't know I had podcasting in me, but here I am.
The podcast bug.
I have the podcast bug. It's not going to go away. I'll be I'll be lurking in the podcast background, for the foreseeable future. So thank you so much again. It's been a pleasure. And on that note, one last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Stitcher, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find more information on all of the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow us on Twitter at BPC_bipartisan. I'm Rachel Iacono. This Week in Immigration was created by Theresa Cardinal Brown. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Theresa Cardinal Brown and myself. Ethan Plotkin produces and edits our show. The executive producer of BPC Podcasts is Lucy Manning. See you next time on This Week in Immigration.